The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this session of the Kansas Supreme Court. I would ask Mr. Shima, the clerk of the appellate court, to please call the morning docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Tuesday, December 15th, 2020 consists of one case. Appeal number 121316, State of Kansas versus Joshua L. Knapp, Allen County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Your Honor, may it please the court, Mr. Joshua L. Knapp, who is the defendant appellant in this case, appears by and through counsel Forrest Lowry, present and ready for argument.
May it please the court, Jerry Hathaway, Allen County Attorney, appears for the state of Kansas, appellee, present and ready for argument.
Thank you, counsel. Mr. Lowry, you may begin.
Thank you. This case revolves around a murder that occurred in Allen County back around March 13th of 2016. The defendant appellant, Joshua Knapp, my client, was eventually charged with first-degree murder along with 2 counts of interference with law enforcement. After a 4-day jury trial, he was convicted of first-degree murder and the 2 counts of interference with law enforcement. He was sentenced to a hard 50 for the murder. The sentences for the other 2 charges, of course, were far less, and they ran concurrently with his 50-year sentence. So he received, in effect, a sentence of 50 years to life. Numerous post-trial motions were filed, including a motion for a new trial and others. They were all denied. And that is essentially what we are here for today. The case basically arose from a series of illegal drug transactions that involved several people, some of whom testified at trial against Mr. Knapp. They included Amber Boken, most importantly, along with Rhonda Jackson, both of whom were charged with first-degree murder, and both of whom took lesser sentences as part of plea deals to testify against Mr. Knapp. The defendant appellant has argued in our brief that there are 2 arguments, and basically they are dependent on each other. The first one is that there was accumulated error to the extent that if any one of them had occurred alone, we probably wouldn't be here, or we wouldn't promote that argument. But because there were 5 instances, well, at least 5, and then one other that I want to touch upon as well, that the accumulated error basically denied my client fair trial. The trial attorney at the time moved for mistrial each time these occurred, and they're noted in the brief. He was denied each time on most occasions, not all of them. He was allowed to, the jury was admonished not to pay attention to what had just been said and to disregard. And the words were stricken from the record. Our contention is that that kind of remedy really is no remedy at all. You can't unring a bell. That's an old saying in the law because it happens to be true. And the problem with that is that the jury heard it. And then after the trial judge urged them and told them and ordered them to disregard it, that simply cemented in their minds, in our opinion, that this was pretty significant and maybe they ought to pay attention to it. I think that's
Counsel.
what happens in juries.
Counsel,
I'm sorry.
if I could interrupt you briefly, are you, just for clarity's sake, the evidence that you're describing, are you referring to some of the testimony about Mr. Knapp, quote, doing this before, trying to run someone off the road, or having a fight? Is that the evidence that you're talking about?
Those are three of the instances. The other two are the fact that one of the defendants, well, one of the witnesses rather, met Mr. Knapp and became acquainted with him in the Cherokee County Jail. And there was, that was number 4. And then number 5 was, well, one that you mentioned, James Myers testifying that Knapp once tried to run him off the road. Those are the instances we're talking about.
So can you back up a little bit and articulate how, for us, how those statements violated some evidentiary rule or otherwise should not have come in?
Well, there was an order in limine preventing evidence of other crimes or other evidence of other bad acts. And
did the court make a ruling that those statements violated the motion in limine?
No, the court did not make that ruling. We made that allegation. The court believed, I'm sorry.
No, I'm sorry as well. But just to sort of, I hope, cut to the point, isn't that something that this court would have to resolve before we get to your arguments about prejudice and cumulative error? In other words, don't we or some court have to have a finding that those statements were actually error?
In my opinion, in our opinion, without saying so specifically, I think the trial judge implied as much by asking the jury to disregard what had just been said in nearly each instance and striking it from the record. So it was enough of a problem that the trial judge believed that some kind of curative comment had to be made to the jury. I mean, he didn't rule simply that there had been nothing wrong had been said. He simply said it can be cured by simply admonishing the jury to disregard. So, yes, do you have to find that it's error beforehand? I think you can. I don't think it depends on what the trial judge said specifically, except that he certainly regarded it as error, or he wouldn't have issued curative instructions.
Mr. Lowry, go ahead, Chief.
No, go ahead, Mr. Justice Rosen.
I'm interested in the comment you made in your opening kind of comments that somehow an admonition or a limiting instruction compounds the problem. Speak to me about that. What is a trial judge supposed to do when there's an objection and the ruling is, yes, that should not have been disclosed or come into evidence? And what is a trial judge to do? Ignore that? Admonishment or limiting instruction is a typical kind of cure that trial counsel look for when these kinds of errors, or at least these kinds of that type of evidence is referred to. I'm curious about that because you said that compounded the problem, made it worse.
In my experience, Mr. Justice Rosen, any trial court that allows testimony of other wrongs extraneous to the facts at hand, in violation of a limiting order or simply in violation of good practice and best practices, puts the trial in a catch-22. I understand your point. You know, what is a judge to do? The point is there isn't much a judge can do to cure the problem. He can say, yes, disregard, but that probably is the only thing he can do, but that's a pretty weak, it's a pretty weak resolution to the problem. I think the problem is just out there. No matter what the court does, the problem is just out there because somebody allowed it in. The court allowed it in, somebody allowed it in.
My question was going to be very much the same, Mr. Lowry, so I don't
Okay.
still have a question.
I'm sorry, do you want me to address that again?
No, you're fine. You answered my question as you answered Justice Rosen. So I just wanted to let you know you didn't need to pause for my question.
Okay, thank you very much. So there were accumulative errors, sorry. One of the worst ones, however, occurred on, and I mentioned it on page 8 and 9 of my brief. And this is a sworn statement by a missing witness, Matthew Allen Broyles. Now, Mr. Hathaway in his brief went into a fairly exhaustive explanation of all of the state's efforts to find Mr. Broyles. I don't think I dispute that. I'm not disputing that he was unavailable. I'm simply saying that his testimony, unredacted, was extremely prejudicial. The last part, well, it wasn't just the last part. It was on the top of page 9. I referred to a question. Okay, during the interview on the 25th of March, you mentioned to me that Jessica told you that they, meaning Josh and Amber, had tortured Jim, or had tortured the kid in Jim's garage. Was that a truthful statement? Answer from me, question, yes. Yes, I heard that. And then he qualifies it by saying, but everything, that's hearsay on that's what she. And then the question is, okay, Jessica didn't tell you that. And then he goes on to say, yes, she did tell me that, but that's something that she had heard also. I've heard about 50, 60 different renditions of what happened. I also have heard that they found 9 different body parts behind Amber's houses, drugged from a pond. I've heard several different things, but none of them I can say truthfully that I know for a fact. Well, it's fine for him, it's fine for Mr. Broyles in an unredacted statement that at least during the trial was not subject to cross-examination, made wild allegations about heinous acts by my client and Amber Boken. But the point is, now it's out there. And now we have not only the grisly aspects of the murder itself for which he was convicted, for which he was on trial, but we've also got allegations, or at least rumors, that he was torturing somebody in Jim Meyer's garage. I'm sorry?
Mr. Lau, I'm going to just interrupt real quick because your time's about out.
Okay.
On this sworn statement, my understanding is that this was actually requested and agreed to by Mr. Knapp and his counsel at trial. Is that correct?
No. My trial counsel objected to reading the entire statement being admitted.
So it wasn't the statement itself, it was the differences between the redacted version and the full version?
Well, I'm not sure there was a redacted version. I think the full version got in there. And the trial counsel objected to using the statement at all.
Was there an objection to this specific testimony, or an objection stated that this included 6455 evidence? Or was it just a broader, more global objection to the use of the statement under the circumstances? Inability
as memory serves, and I should know this, but I believe that it was objected specifically to as 6455 evidence that should not have been allowed in. That's my recollection. Either way, I would argue that it was plain error to have allowed that statement in, making those allegations against my client that were unsubstantiated. And am I out of time now?
You are.
Okay.
If
That went
you
more
want
quickly
to
than I.
quickly wrap up before we go to break, you may.
Thank you very much. I will simply say that as far as my second argument, which depends upon my first, or which supports my first, this was not a case of overwhelming evidence. As in one of the cases cited, maybe I think by both attorneys in their briefs, simply allegations stated without physical evidence does not mean that there is overwhelming evidence, and everybody who testified against my client, almost everybody, had something to gain by doing that. So I'll reserve the rest for rebuttal. Thank you.
Thank you, Mr. Lowry. Mr. Hathaway?
Thank you. May it please the court. The key question here in our minds, in my mind, is were there errors during the trial, and was the evidence so overwhelming that those errors can be found harmless? I think that's, at least through our case law in this state, that is the key test. Justice Stiegel asked about, Justice Stiegel, I'm sorry, I mispronounced that, asked about the errors themselves. I think to piggyback what Mr. Lowry's talking about, those were addressed when they came up, and they included what could be considered, some of them, 6455 evidence, or the fact that the defendant met one of the witnesses in jail in a different county, and those types of things.
Counsel, are you conceding that 6455 was violated in the trial?
I think in some of those instances, yes, when witnesses talked about what could be construed as other crimes. I think a couple of the instances, including the one where he was supposed to have gotten into a fight or had a fight with Mr. Cook, who was the decedent, could be argued either way as whether what a fight actually is, whether it's a physical fight, meaning battery, or a verbal fight. But
well, whether it could be construed either way is different from whether it actually violates 455, right?
Thank you. And I don't believe that one did violate 6455. I believe the judge found that it did not. The others were given curative instructions to the jury, and the jury was admonished with regard to those. But what I'd like to focus on is it's easy to say the evidence wasn't so overwhelming, except the fact that the evidence in our mind was overwhelming. There were two eyewitnesses to the events that led to the final piece in this puzzle of taking Mr. Cook's body to the Neosho River, dumping that body in the river. And when the body was dumped in the river, Mr. Cook actually began to swim. He was still alive. Two witnesses testified in this trial that at the river's edge, Mr. Knapp then went into the river, and while neither could say they saw a knife in his hand, they saw him making stabbing motions to Mr. Cook's body in the river. And then he came out of the river and had to take all his clothes off because they were all wet. That's two eyewitness accounts of the state's theory of the case and what the evidence showed, because obviously numerous days, numerous weeks later, that's exactly where Mr. Cook's body was found, at the edge of the Neosho River. The other testimony that I think lends itself to being overwhelming in terms of Mr. Knapp committing this murder was Mr. Myers' testimony that the next morning, he and Mr. Knapp took Mr. Myers' truck, which was one of the trucks that was used to transport Mr. Cook's body, took it to the car wash the next day to wash out the blood. Also, Mr. Myers testified that the next day following this murder, that Mr. Knapp contacted him, and they took a bag of those wet clothes and Ms. Boken's bloody clothes, along with various other things, and took it out into the country with Mr. Myers and burned all those things, which obviously led to the interference charges with destruction of evidence. It's the state's contention that that testimony in and of itself is overwhelming, whether or not there were violations of 6455 evidence. Those violations, when they occur, it doesn't matter why they occur, although we cite in our brief that obviously these were, when you read the record, non-responsive answers to questions by myself. A great example, and we cite this in our brief, is Mr. Cagle testifying that he met Mr. Knapp in the Cherokee County Jail. The question was, how do you know him? These witnesses were all prepped numerous times with regard to what was appropriate to say and what was not appropriate to say. However, I will say that in my experience over the years, as much as you can prep a witness, it's amazing sometimes what comes out of their mouth when you ask an innocuous question. Many of them want to tell a story even after you prep them, telling them what they can and can't say. It's our contention that the curative nature of what Judge Kreitz did at the trial level, including admonishing the jury to disregard statements and striking them from the record, is exactly what exactly the one thing a trial judge has when something like that comes up in a trial. You know, a jury is presumed to follow the law, and a jury is presumed to follow the instructions given to him by the judge. And I think that happened in this case. The state's theory, to go to Mr. Lowry's last argument about hearsay testimony, and again, we went into an extensive argument about this in our brief, but this aspect of Mr. Cook being tortured somewhere else was never part of the state's theory of the case and was never presented in that manner. So that statement was, our argument is that's not a hearsay statement, was never admitted for the truth of the statement itself. That was never part of the state's theory of the case. The state's theory of the case followed the evidence that we were given, in fact, which was that Ms. Boken and Mr. Knapp planned this murder, started carrying it out here in Allen County, and eventually led them to the banks of the Neosho River, where they dumped Mr. Cook's body. We feel and we argue that that evidence and the testimony from two eyewitnesses who were at the river's edge that night about what transpired is in fact overwhelming. And whether or not there were any errors with regard to 6455 evidence being mentioned, we feel that they should be held harmless, and the fact that a jury would not have come to a different decision based upon that overwhelming evidence.
Counsel, what's your recollection about the admission of the sworn statement?
In terms of what, Justice Biles? Just
I'm about whether there was an objection. I mean, Mr. Lowry was talking about maybe some kind of objection on one grounds, but not another. And I'm just trying to figure out how that statement got admitted.
Justice, my recollection is that the trial counsel for Mr. Knapp objected. I think Chief Justice mentioned this term, made a global objection to allowing those statements in because the witness wasn't there to be cross-examined during trial. And as Mr. Lowry pointed out, we went into an extensive, both pre-trial in this case, and tried to make an extensive record of everything that law enforcement did to try and locate Mr. Broyles, who was the unavailable witness. We did that during the pretrial motion. Obviously, Mr. Knapp's trial counsel once the court ruled that the witness was unavailable and these statements could be read into the record, made a global objection to that. And I think, as Mr. Lowry pointed out, I think we went into an extensive detail of exactly the steps taken by law enforcement here in Allen County to try and ascertain the whereabouts of Mr. Broyles. Ultimately, the trial court found him as unavailable, and because of that, he ruled that the previously sworn statements and testimony could be read into the record. That would be my recollection.
Counsel, on that point, my understanding is there was also an extensive discussion amongst the court and counsel about which portions of the statement would be permitted to come in, and that ultimately there was an agreement on limited redactions and an agreement on the redacted statement. Is that correct or not correct?
Justice Stiegel, I'm sorry, but maybe it's been so long. It's certainly not something I looked at in preparation for this argument. I truly don't recall an agreement on redactions of those statements, and I believe the statements were actually just read in as they were. If there was, I'm sorry, I don't recall that.
Do you know if the statement itself is in the record, or do we just have the transcript?
I do not know if the statement itself is in the record. There were two statements. One of them was a preliminary hearing testimony. So that should be in the record, yes.
But what we're calling the statement is not in the record?
The sworn, the one was the preliminary hearing testimony. There was another sworn statement that was read into the record during the jury trial. And it should be in the record, Justice Stiegel. I have not reviewed everything that is in the court record, certainly recently.
Would you familiarize me with the source of the sworn statement? Is it from a court proceeding, or is it from some other investigation?
It was an investigative sworn statement, Justice Rosen.
And so it was not subject to cross-examination or and the like. Is that right?
That is correct. And obviously the preliminary hearing, his testimony at preliminary hearing obviously was. If there are no other questions, I believe I think I'm gotten through the fact that we believe the overwhelming evidence in this case, including two eyewitnesses who testified as to the final acts that led to Sean Cook's death, along with witnesses who testified to the acts after that death, including destruction of evidence, is so overwhelming that even if this court were to find there were errors during this trial, that they would be found harmless in the face of that overwhelming evidence. So if there are no other questions, I just thank you.
Any other questions? Thank you, Mr. Hathaway. Mr. Lowry, you reserve 3 minutes.
Thank you, Judge. Thank you, Justice Leckert. Let me respond to the state's allegations that there was overwhelming evidence. I think that's what I want to concentrate on for my rebuttal. I believe that the state is in error about that. I think their reading of the trial transcript, and of course, Mr. Hathaway was involved in the trial itself, but my reading of the transcript is that there was not overwhelming evidence. Amber Boken said several times, or at least once or twice, that other people had committed the murder. She accused other people of doing it. Mr. Knapp was not the first person she accused. She was also charged with first-degree murder. She had everything to gain by turning on somebody else, and she chose Mr. Knapp to do it. There was no DNA evidence at the scene connecting anything to Mr. Knapp. Ms. Boken's clothing was bloody. Mr. Knapp's clothing was not bloody. His was wet, according to her testimony, but we never got that clothing. we never got that clothing in the fresh state. We never saw her clothing. We never saw his. And there were some remnants of clothing burned that I think officers found, but that doesn't connect Mr. Knapp to anything. I think really what you have is you have people accusing Mr. Knapp of having done this without any physical evidence other than the body. And that doesn't connect him to Mr. Knapp in only the sense that Amber Boken, who had a great deal to lose by not testifying, decided to point the finger at Mr. Knapp. So I don't think that the evidence is overwhelming, and I think in light of the errors that occurred during the trial, these convictions should be overturned and remanded.
Mr. Lowry, can you back up to the investigative sworn statement? Was there an agreement by trial counsel, defense counsel, that that statement was or effectively constituted a deposition and was admissible under 460C, 6460?
No, I don't, Mr. Justice Wall, I don't believe that was the agreement by defense counsel. My understanding is that he simply objected to admission of the whole thing.
On hearsay grounds?
On hearsay grounds, and I think it was mainly hearsay grounds, and I certainly made that allegation in my brief, but I would also urge that even if it were admissible under hearsay grounds, it is so damaging and so prejudicial that it should not have been allowed before the jury.
Any other questions? Okay, thank you to both counsel for your arguments this morning. The court will take this appeal under advisement, and court is now in recess until 11 a.m. this morning.